I'm Esther and welcome to this second part of my two-part series on defamation law in Australia. In this episode I'll be talking about cases, and that's to illustrate some of the terminology that I discussed in part one. If you haven't seen part one yet, then I recommend you go and look at that. It'll help you to make sense of what I'm talking about in this one. The cases will illustrate some of the defences, and it's really about the practical application of defamation law in Australia, how that plays out. In 2018, I successfully defended a defamation claim brought by Serge Benhayon. In that case, I pleaded the defences of justification, that's truth, honest opinion and qualified privilege. And I had successes with all of those defences, and especially a very big success with the defence of truth. I proved 36 very serious imputations about Serge Benhayon substantially true, including that he is the leader of a socially harmful cult. Now, it's really very satisfying to be able to take a defence of truth to court and bring that evidence and really vindicate yourself in front of the tribunal of fact. So Serge Benhayon can never sue me again for making the allegations or stating that he is a cult leader, for example. If you want to know more about the Benhayon versus Rockett case and see a list of the 36 imputations that I proved true, then visit my blog. There's a link below this video in the About section on YouTube, and also I'm putting some time signatures in so you can skip through to chapters within this video if you like, and perhaps some links to further materials available online. This case is a case of social media defamation, where a young man, he was only a year out of high school, decided to put up some social media posts about a teacher at his former high school. Now, he was never a pupil of that teacher, but for some reason he developed some sort of grudge against her. So he put up these tweets and apparently some Facebook posts. She was very upset by them and immediately took sick leave. She also sued him for defamation. As soon as he received the defamation claim, the young man took the posts down and he issued an apology to the teacher. He then filed a defence. He pleaded at first truth and then qualified privilege. However, both of those defences were struck out by the court. Usually what happens there is that the opposing party will apply to the court to strike out or cut from the pleadings something that they think that is unsupportable. So this is a real sort of cautionary tale. If you do get into trouble for defamation, it's a good idea to get proper legal advice and some help with filing a defence, because if you don't plead it correctly, you can run into all kinds of trouble with the other side bringing you to a hearing, and if the pleadings are found to be faulty, then they'll be struck out and you can be hit with the costs of that. So anyway, his defences were struck out. He didn't participate in the proceedings from there on, and he didn't attend any of the hearings. So the teacher was issued a judgment in her favour, so she was found to be defamed by these posts, and she was awarded damages. Now, the damages were $85,000 and $20,000, so $105,000 in total. So the $20,000 of that, though, was aggravated damages. Now, in determining aggravated damages, the court took into account that this young man had initially pleaded this defence of truth, but in his particulars of truth, he just put in a bunch of these unsubstantiated allegations. And the judge remarked in this case that the defence of truth, when it is spurious, is particularly hurtful to a person who has been the subject of such unsubstantiated allegations. So this was found to be an aggravation of the damages. If you get sued, the court takes into account the way you conduct the proceedings. So it's really worth bearing that in mind. And I imagine he was ordered to pay the teacher's costs, and I would estimate that those would have been another $30,000 to $50,000. The next case is a long-running dispute between two people. This is Katie Milne, who is a local politician. She is the current mayor of Tweed Shire, and Bob L., who is a billionaire property developer. A number of years ago, Bob L. sued Katie Milne for defamation and did so successfully. So what had happened was Katie Milne had sent out a group email to over 70 people. She had made some statements in that email about Bob L. making political donations and some connections he had with some people that, might be of allegedly questionable character. Now, so he sued her for that, and in her pleading, she did not plead truth. She did not try to prove these allegations were true, but she pleaded the defences of honest opinion and qualified privilege. However, those defences did not succeed, and she was ordered to pay damages of $15,000. Now, $15,000 in the scheme of things, especially in terms of the cases that I'm looking at today, is on the low end of the damages scale. But the reason for that was that the court, in hearing evidence, only heard evidence of 3 people reading the email. So even though it was addressed to quite a lot of people, there was simply no evidence given that it was read by more than 3 people. So I imagine that if it had been more widely read, then the damages would have been a bit higher. So after he won his case, Bob L. was approached by the Gold Coast Bulletin for a comment. And the journalist says to him, "I have heard speculation that the court case could bankrupt Katie Milne. Do you know whether that is happening?" Bob L. replies, "I hope that's true. She got what she deserved." The journalist says, "But that might mean she would not be able to retain her position as councillor." Bob L. says, "She's not a fit and proper person to be a councillor. The court gave us that result, and they seem to know what they're doing." The Gold Coast Bulletin published those words, or at least some of them, and Katie Milne made a complaint to the Gold Coast Bulletin. They issued an apology which read, and I'll just abridge it a little bit. We published a statement by developer Bob L. that Tweed Shire Councillor Katie Milne was not a fit and proper person to be a councillor. The Gold Coast Bulletin does not share that view and unreservedly apologises to Councillor Katie Milne for the publication. Now, Katie Milne says that this is an example of a settlement. So in settling that, Katie Milne has said that she wasn't given any money in damages for that. She settled, just for this apology. They might have paid her legal bills, though. That I'm not too sure about that. But then Katie Milne went on to sue Bob L, and she won the case, and she was awarded damages of $45,000. Katie Milne filed a defamation claim, and she said that her reputation had been damaged by Bob L imputing that Ms. Milne is not a fit and proper person to be a councillor. And in his pleadings, he didn't attempt to prove that that was true, so he didn't plead truth. He pleaded the defence of honest opinion, Section 31 of the Defamation Act, and on the defence of fair comment at common law, which is quite similar. Now, there's 3 requirements for the defence of comment or honest opinion to be upheld. The words themselves must be a comment or the expression of opinion as distinct from a statement or assertion of fact. Second, the comment must be made or the opinion expressed on a matter of public interest. And third, the factual basis for the comment or opinion must be identified in the published matter or be notorious. So Bob L's defence failed in 2 parts there. The comment was found to be expressed as a matter of public interest simply because Katie Milne is a local politician, a public figure. But the judge's remarks in this case were that I conclude that the imputation is an imputation of fact, so it was found to be an expression of or an assertion of fact rather than an expression of an opinion, and in any event is not an imputation which, in accordance with the requirement to establish the defence, is based upon facts which are recited in the publication. So this is an important thing to remember. If you want to plead a defence of honest opinion, you have to recite the facts within the publication or include the proper material within the publication. So the judge remarked on this, and he said that the court does not accept that the previous judgment from the defamation claim that went before, where Katie Milne was found to have defamed Bob L, the court doesn't accept that that concluded that the plaintiff was not a fit and proper person to be a counsellor. And the court didn't accept that Bob L honestly believed that that was the effect of her losing that case. So Bob L's honest opinion defence didn't stand up, and yes, he was ordered to pay damages to Katie Milne. The next case is a case of a dispute between neighbours, and these were neighbours in an apartment building in Sydney, and this was between the chair of the strata committee, so sort of a residence committee, he was the chairman, and a tenant of the building. And what had happened here was that after the tenant moved in, the chairman noticed that she often left her mailbox unlocked. And so he notified her of this. He said, he wrote her some emails and said, are you aware that your mailbox is unlocked? And he requested that she lock her mailbox. And over time, about a year I suppose, he sent her a few emails personally to her email address, not to anybody else, and just sort of said, well, it would be helpful if you could lock your mailbox. Now, around that time, there was a problem with mail theft in the neighbourhood, and people's mailboxes had been broken into and their personal documents had been used in identity fraud. So this was quite a serious issue, and the chairman went to the trouble of taking a newspaper clipping from a recent report with a statement by a police officer talking about mail theft in the area, and requested again that this tenant lock her mailbox. He tried to reason with her and told her that by leaving her mailbox open, that she was putting the security of the other mailboxes at risk, because a potential thief could come along, take a look at the type of lock that was used, and then use that to make a key that could probably fit a skeleton key that could fit all of the mailboxes. So reasonably made these requests. She ignored all of the requests. Eventually the mailboxes were broken into. So the chairman then wrote a couple of group emails to 17 residents, including this one tenant. He didn't single out this tenant at all in the group emails. He just put out a group email talking about the mail theft and the security of the mailboxes, and please lock your mailboxes. Finally, the tenant decided to reply to this email that went to the group. And in replying, she replied to the whole group. She made sure it went to everybody who was addressed. And in that email, she took a lot of the prior email correspondence from the chairman. She pasted it below this message. And her reply to the chairman was really pretty impolite and defamatory. So the judge in this case found that the defendant's email falsely implied that the chairman had unreasonably harassed and acted menacingly toward her by sending threatening emails, and that her email also said that the chairman was a small-minded busybody who wasted fellow residents' time on petty items concerning the running of the building. The chairman was very upset by this reply, and we're talking about a 78-year-old man who, by the time this went to court, he needed 2 walking sticks to get to the stand, and he was very flustered in giving his evidence and evidently upset by the whole episode. When he received the reply, he put a letter into the tenant's letterbox. He asked her to apologise to all of the people that she'd addressed the email to. She ignored that, and so the chairman sued her for defamation, and he won. And he was awarded $120,000, so that was $90,000 in damages and $30,000 in aggravated damages. So the defendant in this case did file a defence. She pleaded justification and persisted with a defence of justification. Also honest opinion and common law qualified privilege, which is the defence of reply to attack. The judge was pretty scathing about all of this. In pleading justification, the defendant said that the evidence that the chairman was a busybody and a person who threatened and harassed her was this correspondence from him, these emails, where he had actually politely and intelligently and articulately and reasonably asked her to cooperate with the security of the building and lock her mailbox. So that was found by the judge to be not to be evidence of justification. The fact that he'd sent her some polite emails did not prove the truth of any of these damaging imputations. Her defence of honest opinion also failed at every step. It was found that the ways that she expressed these imputations in her reply email were assertions of fact, not opinion. Even if they were opinion, that opinion was not rationally based on any proper material that was provided within the email. That's an important point. There has to be a rational basis for this opinion, and the material has to be provided within the publication, and it wasn't. Also, the material she used as proper material that she'd included in her email was not true. Her reply, in replying to all of these people and getting stuck into this chairman, was not in the public interest. Furthermore, the defence of qualified privilege failed because, or this defence of reply to attack, because the chairman's emails were not an attack. He wasn't attacking her at all. He made no slurs on her character. He was just simply asking her to cooperate. The judge found that the tenant acted maliciously in publishing this email, because she knowingly misrepresented the chairman's correspondence by selectively cutting and pasting it into her reply. So that was evidence that she knew that the allegations she was making against him were false. The judge also found that the reply email was sent for the purpose of humiliating, belittling and insulting the plaintiff in the most hurtful way possible. And it would be fair to say that every sentence of the defendant's email in reply struck a blow at the plaintiff and was intended to ridicule and humiliate him in every way. So that's another characteristic of malice, is if you set out in your publication to hurt the plaintiff. In determining awarding aggravated damages, these extra damages to the plaintiff, the judge took into account, again, similar to the case we heard before, that pleading and persisting in the defensive justification may increase the harm. I'll read out what the judge said about awarding aggravated damages. So, a substantial award of aggravated damages should be made by reason of the strong evidence that the defendant's conduct was improper, unjustifiable and lacking in bona fides. The falsity of the imputations, the conduct of the defendant at trial, namely knowingly bringing a baseless defence of justification in that the defendant's cut and paste exercise misrepresented the prior correspondence from the chairman, and the recklessness of the publication, as well as the defendant's refusal even to read, let alone answer the plaintiff's requests for an apology, would each individually warrant the award of aggravated damages. I imagine that the tenant was ordered to pay the plaintiff's costs, and look, you just have to guess that that would be around $100,000. This is a case of defamation of a highly respected orthopaedic surgeon by the name of Dr. Munjed Almaderis by a former patient. And the former patient's name is Gerardo Mazzella, also named Gerard Duncan. Mr. Mazzella had an operation with Dr. Almaderis, and he claimed that he had been harmed by this operation. It was a hip operation, and that it had caused some sort of ongoing physical effect. Now, he developed a grudge against the doctor, and Gerard Duncan, or Gerardo Mazzella, and his brother Rodney Duncan set up a website publishing all sorts of false and defamatory allegations about the doctor. And the doctor filed for defamation, but these two brothers did not participate whatsoever in the legal proceedings. They were made aware that there was a defamation claim against them and that proceedings were going on, but they did not file any kind of defence, and they did not make any appearances at court. So at the end of 2016, the court ordered a default judgment in Dr. Almaderis' favour and issued a court injunction for the brothers to take the website, or websites by then, down. Apparently the brothers ignored those court orders. In 2017, the court went to another hearing to determine how much to award Dr. Almaderis in damages. To do that, they heard evidence as to the falsity of Gerardo Mazzella's allegations. So what the doctor and his legal team did was subpoena a whole lot of documents, including Mr. Mazzella's medical records, and there just simply was no evidence whatsoever that he had been harmed by this surgery done by Dr. Almaderis. The court also heard evidence of Dr. Almedeiros' reputation. And his reputation was so impeccable that the judge called him the perfect plaintiff. So Dr. Almedeiros was a refugee from Iraq. He's a very highly respected surgeon who has pioneered these techniques in prosthetic surgery. And he's done this enormous amount of charity work where he's helped refugees and bombing victims who've had limbs amputated. So he's done this incredible amount of charity work, and he has been twice nominated for Australian of the Year. So this is not the sort of person that you would go around defaming. The judge awarded Dr. Almedeiros $480,000 in aggravated damages plus costs, plus orders to either imprison or sequester property from the brothers if they did not pay the damages and take down the website. Now, it should have really ended there, but it didn't. I don't know what's happened with the brother, Rodney Duncan. He has not been the subject of the two further hearings after that hearing in 2017. So I imagine that means he may have complied with the court orders, or complied with his part of the court orders. But Gerardo Mazzella, has not. And in 2018, those websites were still online. As far as I know, they are still online. Gerard Duncan was found guilty of civil and criminal contempt of court for defying court orders. In May of 2019, this year, the court then went to another hearing, and because the website apparently is still up, the court sentenced Mazzella to a 2-year prison sentence, plus a $40,000 fine on top of everything, plus costs. And the court has issued a warrant for Gerardo Mazzella's arrest. Now, I used that case to illustrate the importance of defamation law, and that really people do have a right to protect their reputation. This is a very good case to illustrate that, because not only is this a case where a doctor's reputation was hurt and his feelings were hurt, but this is a case where this kind of material that was published online could have deterred patients from seeking some of the best medical help available. So, you know, this is really depriving members of the public of a very valuable medical service. I spoke in the first video about the objectives of defamation law and balancing the interests of the public and free speech, you know, the public's right to know, with a person's right to protect their reputation. But in this case, we're talking about false information, and free speech, the public's right to know, doesn't really extend to the right to know material that's false, lies. The public has a right to facts, you know, factual material, or material that is legitimately in the public interest. And this kind of rubbish is not. I don't know what's happened, whether or not Gerard Duncan is still at large, and whether or not these websites are still online. The next case involves television personality Don Burke, and he's somebody whose reputation has taken quite a beating in the last few years, because a number of people have come forward and accused him of bullying and sexual impropriety. Don Burke agreed to do a television interview after a lot of these allegations came out on a program called A Current Affair. And in that program, he made some admissions about his bullying and his extramarital affairs, but generally denied the allegations of sexual misconduct. And in doing so, he named one of his accusers as somebody who was telling lies about him and falsely accusing him. And the name of that accuser is Wendy Dent. And Wendy Dent then sued him for defamation. And Don Burke decided to defend this case, and he defended it successfully. In his pleadings, he denied that the interview conveyed the pleaded imputations, and he pleaded several defences, including truth, reply to attack, that's common law, qualified privilege, and statutory privilege. But the court never got to his defences. The court found that, in fact, the interview did not convey this imputation that Wendy Dent was any of the things that he said she was. In essence, what it boils down to is that Don Burke performed so badly in this interview that he came across as having no credibility. And even though he made what you would say are probably defamatory remarks about Wendy Dent, that nobody would really believe him. But I'll read what the judge says. And the judge says, "I accept that if the statements made by Mr. Burke, the defendant, in relation to the allegations made by Ms. Dent were examined out of their context, then the imputations would be made out." That is, people would understand that he had defamed her. That is because the defendant himself does say expressly or impliedly that the allegation that she makes is false, and that she makes it as part of a witch hunt. However, when considered in its context, the position is different. The proposition that the events alleged actually occurred is put strongly and persistently by the interviewer. This is Tracy Grimshaw. She puts to him the weight of the number of allegations, the corroborative evidence in relation to some of her allegations, her own opinion about how difficult it is for complainants to come forward, and impliedly their likely credibility in the circumstances. At times, the expression on Tracy Grimshaw's face and the manner in which she responds to Don Burke's statements indicates a lack of acceptance of what he has said. It is a case in which the weight and authority of the interviewer and program is put behind the credibility of the allegations, in contrast to the denials made by Don Burke. So it's saying that as a whole, if you took the comments he made out of context, sure, they're defamatory. But taken as a whole, the interview as a whole, you don't get that impression. And Wendy Dent can't be defamed by this interview because of the impression by the interview, but the fact that Don Burke has so little credibility. And the judge then ordered in favour of Don Burke for the defendant, so he successfully defended this case, and Wendy Dent, unfortunately, had to pay his legal costs. Wendy Dent said after that she felt vindicated, even though she had to pay his costs. She felt vindicated because the court really recognised that Don Burke has very little credibility, and really that the court had sided with her. And a commentator in the media described this as a Pyrrhic victory for Don Burke. Well, a Pyrrhic victory is a term you hear a lot in litigation, and it refers to this historic battle of King Pyrrhus, ancient times, against the Romans. King Pyrrhus had a small army, and of course the Romans had this vast army. But King Pyrrhus managed to win this one really ferocious battle. And that's where you get the term also, winning the battle but not the war. King Pyrrhus nearly lost his entire army. So many of his soldiers were killed in this battle that his army was nearly destroyed, and he had to then flee from the Romans. And he is said to have said about this battle, "Another win like that and I'll be completely wiped out." So this is something that you do see a lot in litigation, where, you know, the battle really is sort of not worth fighting in some cases. Even though you win, you come out worse than if you hadn't fought. Now, Stephen Dank is a controversial and very litigious sports scientist, and he sued the Daily Telegraph a few years ago for a series of articles about his work with football players. And the paper successfully defended all of the articles except for one. Now, in defending the articles, they had a win on the defence of truth for one of these articles, and in that finding it was proven true. And I'll read these imputations out. These are the imputations that were proven true, and it will just sort of show the kind of conduct that this guy was involved in. Stephen Dank administered to football players peptide drugs which were prohibited by the World Anti-Doping Authority. Stephen Dank acted with reckless indifference to John Manna's life by administering dangerous peptides to John Manna whilst Manna was in the remission stage of cancer. By administering peptides to John Manna, the plaintiff accelerated his death from cancer. The plaintiff administered dangerous and cancer-causing supplements to John Manna and other football players, thereby exposing them to risk. The plaintiff's conduct in administering peptide substances to football players was absolutely indefensible and justified one of Australia's leading sports physicians to express his horror. And finally, the plaintiff acted with reckless indifference to John Manna's life because he administered untested peptides to Manna whilst Manna was in remission from cancer. The Daily Telegraph won this part of the case. But then there was one article where the Daily Telegraph had made an error or put in a false allegation that Stephen Dank had injected footballers with the blood-thinning agent warfarin. That was false. And so there were about 4 or 5 imputations in this final article. And the Daily Telegraph managed to prove one imputation was true. And the defence proved an imputation that Stephen Dank oversaw the administration of a physically dangerous medication to Cronulla football players. They found it was true that he'd injected a substance that had not been appropriately tested for therapeutic use by humans and had the potential to cause major bleeding. It should never have been given to football players. Unfortunately, the Daily Telegraph lost for this one article. Then there was a hearing about damages and how much to award Stephen Dank in damages and in costs. And at that argument, the lawyer for the Daily Telegraph argued that the defendant may be able to rely on such facts as he has proved to reduce the damages. Once it comes to awarding damages, you can argue mitigating circumstances, things that mitigate the amount of money you pay in damages. And I talked about this in the first video, that, issuing an apology will reduce the damages. Withdrawing the allegations, retracting them, will reduce the damages. In this case, what they're arguing is that they proved some of this, it's very damaging imputations. They proved this true, and that should reduce damages. The judge said, "I am of the view that the mitigating impact of the true imputations reduces the damages that should be awarded to Mr. Dank to such an extent that there should be no award of damages in this case." She didn't even take into account all of those imputations I read out before that were found about other articles. She said in this case, I only need to rely on this article. There was only one imputation proven true, and that's enough. She said, I've not found it necessary to rely on the other findings to sustain my determination. So in other words, what she was saying was the truth that he'd overseen the administration of a physically dangerous medication to Cronulla football players meant that he didn't really deserve to be awarded damages. And she made the orders that there be judgment for the plaintiff, no award of damages, and that the plaintiff, Stephen Dank, paid the Daily Telegraph costs of the proceedings. So that's an example of a plaintiff essentially winning a defamation claim or part of one, but getting nothing and having to pay really for the whole thing. Now, if I was going to add anything more to this, I would just say, probably reiterate, that if you get into trouble with defamation law, then I really do recommend getting good legal advice, and particularly before you file any pleadings, because that can be costly if it comes down to striking out pleadings. If you don't understand the process or how to plead your case, you can be penalised for that. That can sort of inflate the costs. If you need a lawyer, I personally recommend this firm, O'Brien Criminal and Civil Solicitors in Sydney. They represented me in the critical final stages of Universal Medicine's 2 defamation claims against me. So thank you for joining me, and whether you're somebody who's been defamed, or whether you're somebody who's involved in publishing, or whether you're just a member of the public who's interested, I really do hope you've learned something about the legal process, and good luck with publishing.